So turning to one of our top stories, former President Jacob Zuma plans to bring into question the constitutionality of the establishment of the State Capture Commission of Inquiry. Zuma has filed a 100-page-long affidavit supporting his application for Deputy Chief Justice Raymond Zondo to recuse himself as chairperson of the inquiry. Now, in those papers, the former president says while this is not the basis for which he's seeking the recusal, it does, however, give proper context to his reservations about the constitutionality as well as legality and appropriateness of having Zondo preside over the commission. Let's get you some analysis on this. Now we're joined by a constitutional expert and director at Accountability Now, Advocate Paul Hoffman. He's joining us by Skype tonight. Advocate, always good to speak to you. So how much work will Zuma's legal team have to put in to prove that there is sufficient grounds for Zondo to recuse himself on Monday?
Good evening, Thembekilo, and good evening to your viewers as well. Thank you for the opportunity. The row that the legal team of ex-President Zuma have to hoe in order to have any success in their attack on Judge Zondo and the propriety of his continuing to sit is a long and difficult one. It seems from the line being taken now that the recusal is but one of three legs on the case. The second leg is the constitutionality, and the third is what he calls the appropriateness of the appointment of Judge Zondo in the matter. In order to prove the recusal, he's going to have to establish on a balance of probabilities that there is a reasonable apprehension of bias against him on the part of the Deputy Chief Justice. I think he's going to have some trouble on that, and I anticipate that the Deputy Chief Justice will refuse to recuse himself on the basis of alleged bias. If that refusal transpires, then it is likely that President Zuma's team will ask for a postponement of his evidence to enable them to take the refusal of the application to recuse on review in the High Court. And if the Deputy Chief Justice wishes to continue, despite that pending application, they will seek to interdict him from doing so, and because it's a temporary interdict, they have to demonstrate a prima facie right that is threatened or infringed if the interdict is not granted. It's quite possible that no interdict will be given at all, and that the other legs of the case will come into focus quite sharply.
But based on what you're saying, Advocate Hoffman, apologies for jumping in, based on what you're saying, if there isn't a recusal as the Zuma camp would like to see, we would be in then for another long legal process about the former president's appearance or participation in the state capture inquiry process, which, when you look at the little time that's left for the Deputy Chief Justice and the evidence leaders to complete their work, would have serious implications, I'd imagine, for the final report.
Yes, I'm not sure that the legal process will necessarily be long, and I'll tell you why. If as is anticipated, the recusal application falls on barren ground, then the only way of keeping it alive, and of course ducking and diving and deferring and delaying is the regular tactic of Team Zuma. But they will only be able to keep it alive if they are able to interdict the continuation of the commission while their review proceedings are pending. And they may have difficulty with that as regards the classic recusal aspect of the matter, but less difficulty in relation to the constitutionality point. Now, the constitutionality point is quite an interesting legal interpretation of the provisions of the Constitution that relate to the appointment of commissions of inquiry. People will remember, if they think back to October 2016, that Thuli Madonsela, shortly before the end of her term as public protector, said that she couldn't possibly, and her office couldn't possibly do the big amount of work that is required to investigate state capture, and that the right way forward would be the appointment of a commission of inquiry, but that because then President Zuma was implicated in the allegations of state capture, it was not appropriate for him, as the constitutionally nominated person for appointing commissions of inquiry of this nature, to actually make the appointment. So she asked that the Chief Justice nominate the person to be the head of the commission, and that the terms of reference that she recommended be endorsed by the President, and that he bring the commission into being. Now, if it is correct, as will be argued on behalf of Jacob Zuma, that the Chief Justice has no right to take over from the President in the choosing of the person to sit as the commissioner, then everything that has been done so far has been done unconstitutionally and invalidly. And that argument is going to turn on the interpretation of the provision of the Constitution that says that when the President is unable to act, then other people can act in his place. And the other people who can act in his place do not include the Chief Justice. It's the Deputy President, a member of Cabinet, or somebody, the Speaker of the House, or somebody nominated by the Speaker. Mm-hmm. So that aspect of the matter is going to raise a legal argument which will be met, but it certainly got more legs than the recusal application. It will be met by an argument on behalf of the Commission that if Jacob Zuma had these serious reservations about the constitutionality, he ought not to have signed the Commission into law, and he ought not to, or into existence, and he ought not to have sat back until the heat was directed towards him before doing anything about it.
Okay.
In fact, that defense is also available on the recusal, because he's known about the grounds for recusal since day one.
So possibly my last question then, Advocate, becomes twofold. A, what would be the harm of the Deputy Chief Justice, the Commission chairperson, sitting out the Zuma portion of the evidence if he does indeed return? And B, if he were to recuse himself, who would then sit in his chair for that portion of the hearing?
This is a very interesting question among lawyers, and it's been debated a lot. And I'm glad you asked it, because the truth is that 34 and counting witnesses have implicated Jacob Zuma in various aspects of the state capture process. So I think that it would be quite difficult to get a sort of substitute off the bench to play out the last few minutes of this game on behalf of the Chief Justice, or even of the Deputy Chief Justice, or even to just deal with the Jacob Zuma part of the evidence. It is too central to the entire mandate. But do not worry about the time running out. The time will not run out if the legal proceedings that Jacob Zuma has in mind cause a delay, and they don't have to cause a great delay if case management is properly done, and if the legal teams on both sides cooperate in getting to finality on the issue. If it takes us beyond March next year, it's perfectly in order for the Commission to ask for the term of the Commission to be extended. If Jacob Zuma persuades the courts, and it'll probably end up in the Constitutional Court, that this is an unconstitutional commission, then the warning that Accountability Now gave right at the beginning will be vindicated, and President Ramaphosa will have to decide whether he wishes to appoint a fresh commission of inquiry to continue the work on a constitutionally compliant basis, or whether he is happy that enough has been revealed during the Zondo Commission hearings for the revamped criminal justice administration to use the evidence that has been led to prosecute those who need to be prosecuted
I'm listening to
and
you say
to
that,
bring about reforms.
Advocate Hoffman, I'm listening to you say that, and a lot of South Africans have already criticized the Commission so far for the millions spent on its running, and if there were to be an extension, one has to wonder about the public sentiment towards its work, whether or not the final outcome will eventually be worth it.
My mother taught me that it is a very bad practice to be penny wise and pound foolish. The pennies, the millions that are being spent on the evidence leaders and on the venue and on the investigators are but a drop in the ocean compared to the trillions that have been looted and that can be recovered if a proper investigation is finalized and if criminal proceedings, assets forfeiture proceedings, and the raking back of the loot is the result of the spending of millions on the Zondo Commission of Inquiry. I do not believe the money has been misspent. I believe that accountability, which is a foundational value in the new South Africa, has been served and has already been served by the work of the Commission. It has concentrated the minds of the previously somnolent Hawks and the NPA, and we are already beginning to see what the National Director of Public Prosecutions calls the pinpoints on the iceberg of corruption in South Africa. We cannot allow corruption to continue. It will destroy the country. The work of the Commission is vital to highlighting the areas that need attention, and it ought to be continued whether by the Deputy Chief Justice or by somebody who is appointed in his place if it transpires that his appointment was not in accordance with the provisions of the Constitution, which would apply when the President himself is not in a position to appoint a commission of inquiry.
Advocate Paul Hoffman, always great to speak to you, sir. Thank you for your time.